The Humboldt County Civil Grand Jury would like to welcome you to listen in on its report, Behold, the Department of Mental Health's Management of the Public Guardian Office and Patients' Rights Advocate. Summary. Public guardians in California handle some of society's most vulnerable people. These public servants are hired by the county and appointed by the court to manage the personal, financial, and medical needs of those suffering grave mental or physical illness or disability. Deputy public guardians across the state typically manage dozens of clients simultaneously, assisting them in tasks ranging from involved financial and medical decisions to the provision of basic necessities of day-to-day life. Like the Public Guardian Office, patients' rights advocates assist a segment of a given county's vulnerable population, those receiving mental health-related treatment, and especially those held involuntarily at psychiatric facilities. In Humboldt County, both the Public Guardian Office, hereafter known as the PGO, and the Office of the Patient's Rights Advocate, hereafter known as the PRA, are managed by the Department of Mental Health, which is within the Department of Health and Human Services, hereafter known as DHHS. This report is not an evaluation of the overall performance of DHHS and the mental health, but an investigation of two areas where mental health should reconsider its practices. The Humboldt County Civil Grand Jury, hereafter known as the Civil Grand Jury, learned that members of the Humboldt County's Public Guardian Office were not participating adequately in the care conferences for clients at skilled nursing facilities, hereafter known as SNF. The excessive caseloads carried by the deputy public guardians hinder the office's fulfillment of its obligations to the conserved. The subsequent investigation showed that Humboldt County has been experiencing steady annual increases in both its total number of clients and the average caseloads borne by each guardian. The average caseload of each deputy public guardian dwarfs that of counties with populations 2 or 3 times the size of Humboldt. During its investigation, the Civil Grand Jury learned that mental health had recently imposed specific restrictions that limited the PRA's ability to access patient information on a daily census, in mental health meetings, and in regular reports about denial of rights. It was alleged that these new implementations of the existing confidentiality policy was adversely affecting and even potentially obstructing the PRA's state-mandated duties. Facility employees who see the PRA's work as critical have described the administration's withdrawal of the census data as reactive, defensive, and punitive. The Civil Grand Jury has concluded that the Public Guardian Office and the Office of the Patient's Rights Advocate are struggling to meet their objectives because of the management of the Department of Mental Health, which has acted slowly to mitigate the problems posed by the growing number of conserved. Although the PGO itself was perhaps not as responsive as it should have been, most of the responsibility for the PGO's inability to fulfill its obligations to clients rightfully lies with DHHS and mental health, who control the PGO's resources and lack an adequate plan for adapting to unforeseen staffing shortages. Much needed efforts might have been taken sooner if not for poor communication between the departments involved. DHHS should request funds for a new deputy public guardian, and the Board of Supervisors should ensure that such funds are approved. Furthermore, DHHS should develop and implement a policy to mitigate the effects of unforeseen events on the remaining staff's workload. The Civil Grand Jury found that while the legal basis of mental health's confidentiality policy is sound, its rigid implementation, redacting the patient's census, the list of detained patients across the county, and regular reports detailing the frequency of denial of rights orders takes the protection of confidentiality to unnecessary and unproductive lengths. This is especially true in the light of the explicit allowances made for county employees who have completed the department's annual Health Insurance Portability and Accountability Act, hereafter known as HIPAA, training. At best, withholding information about patients makes the already challenging job of the county's single PRA necessarily difficult. At worst, it could actually rise to the level of denying certain clients their legal rights to advocacy. Mental health should ensure that the patient's rights advocate has full access to patient information relative to their duties, specifically as they pertain to the use of the census, the list of the Lanterman-Petrus short clients, the collection of denial of right statistics, and the entire continuous quality improvement, hereafter known as the CQI meeting. DHHS recent funding request for a new deputy public guardian and mental health's ongoing reconsideration of the PRA's duties are reasons for optimism. But until these recommendations are implemented, Humboldt County is vulnerable to potential legal action for failing to meet obligations to both its conserved clients and mental health patients. The looming challenge of caring for the growing number of aging, senior citizens and those suffering from acute mental illness, especially during the coronavirus pandemic of the present and foreseeable future, will only exacerbate these present difficulties. Background: Guardians of the public. No single group of individuals, no segment of our population, more pungently challenges our moral convictions and social values about the worth of human life and of dignity and of rights of the individual than those older people whose mental and physical impairments place them at the mercy of society. This is a quote from Diamond. The name itself, public guardian, speaks to the trust, diligence, responsibility, virtue, and compassion this position demands of those who are given this job. The legal and conceptual basis for the institution of the public guardian in the United States is derived from English law. The 1324 statute, known as the De Prerogative Regis, states that the king shall have the custody of the lands of natural fools, taking the profits of them without waste or destruction, and shall find them their necessities. In early 19th century England and a bit later in the U.S., those suffering from dementia, alcoholism, drug addiction, developmental disability, and the many forms of insanity or feeble-mindedness and incompetency were housed in institutions. At present in the United States, state governments manage the role of dependent caregiver, although laws vary between states. Before the very first California State Public Guardian's Office was established in Los Angeles in 1945 to serve any person unable to administer their own affairs, such persons were institutionalized. But California state hospitals became so overcrowded by 1950 that incarcerating therein constituted a form of institutionalized torture. Hospitals built for several hundred patients housed several thousands, and the Lanterman-Petrus Short Act, the LPS, signed in 1967 and enacted in 1972, deinstitutionalized mental health care and virtually emptied many of California's state hospitals. Several of these facilities closed, and their patients, in some cases, ended up on the streets. In the aftermath of this legislation, the onus fell upon counties to deal with this population. Humboldt County Public Guardian Office. When it is determined that a person needs some level of intervention by referral from a physician, medical or mental health clinician, and the court, a public guardian is appointed to their case. Although Humboldt County's PGO have been overseen by its mental health department for about 4 years, at one time the PGO stood as its own department with the Veteran Services. It was later placed under the Aegis of Social Services after the Department of Health and Human Services was established. The current budgeted staff positions in the PGO office include Public Guardian, who is the head of the PGO, Assistant Public Guardian, who is next in line administratively and supports the Public Guardian, 3 Deputy Public Guardians, the several administrative positions including Auditor, Controller, Financial Assistant, Vocational Assistant, and Office Assistant. Clients and services of the Public Guardian. The clients of the Public Guardian are the conserved and are those deemed to be superior court to be unable to manage their own affairs or according to the evaluation of a qualified physician or psychiatric due to a grave mental or physical illness or disability. They often lack the support of available and appropriate relatives or friends. Conservatorships belong to one of 2 primary categories. The probate conservatorship focuses on financial and medical care decisions, usually for a lifetime. And the LPS conservatorship, which must be renewed annually, requires the management and treatment of persons needing psychiatric care. The conservatorship of an individual client may fall within 2 further subcategories: a limited conservatorship for the developmentally disabled, and a representative payee service whose sole task is managing clients' payments from the Social Security Administration, Veterans Affairs, or disability, and the list of tasks performed by the PGO for the client is quite extensive. First, the interview the proposed conservatee, family members, friends, physicians, psychiatrists, law enforcement personnel, social workers, and others, and then must prepare detailed reports of findings, recommendations to the court concerning family, finances, real and personal property, social history, medical and psychological conditions, and the need for a conservator or representative payee. Next, they must work with the county council in preparing petitions, interviewing witnesses, assisting with trial preparation, and arranging the appearance of clients at court, hearings, and trials. Next, they arrange for the hospitalization, the care treatment, the vocational training, the physical therapy or speech therapy, the outpatient mental health care, the education, and housing of this client. Next, they must negotiate rental payments, investigate extent and nature of conservatee estates. They must locate inventory and protect all real and personal assets. They must initiate applications for and assure receipt of all benefits to which the client is entitled. They must work with a multiplicity of agencies and individuals to arrange for the delivery of services to their client. They must assist case management personnel from other agencies in visiting and monitoring the progress of the conservatee in local and out-of-county placements and to prepare reports of visits. They must provide medically necessary ancillary assessment and case management services to conservatees. And finally, they must attend skilled nursing facilities, SNFs, care conferences. These are but the formal duties of the PGO's job. In assuming the total care and handling of a client's personal, financial, medical, and legal affairs, a host of other tasks inevitably arise, as simple as a client's request for a cell phone. Guardians have immense power over the conserved, whose financial, medical, and psychological well-being is in the hands of their public guardian. Guardians have the authority to remove a person from their home in order to place them in an assisted living facility, and the authority to make medical decisions for them. They can sell, confiscate, or liquidate the entirety of the client's property and belongings. Clients are vulnerable, often elderly, commonly disabled, and by nature of their predicament and circumstances may lack the wherewithal to even understand their civil rights. Thus, administration of guardianships and conservatorships must be held at the very highest ethical and legal standard. The Civil Grand Jury received a complaint that the participation of deputy public guardians in the quarterly care conferences for patient conservatees in skilled nursing facilities, or SNFs, SNF, have been unsatisfactory. The Patient's Rights Advocate and why it exists. Over the course of its investigation of the public guardian, the Civil Grand Jury learned of a potential second and related concern in different office overseen by the Department of Mental Health, the Office of Humboldt County's Patient Rights Advocate, PRA. The origins of this office and the history of California's mental health institutions is tragic, even terrifying. From their inception in the late 1800s, the state's insane asylums were left to operate without much oversight. As a result, conditions inside such hospitals did little for patients' mental health. Persons could be committed to an asylum on nothing more than the word of a relative. Patients who could be held indefinitely were essentially prisoners without sentences, shackled, beaten, abused, and forgotten. Patients were subject to lobotomies, electroshock therapy, psychotropic drugs, and sterilizations at the will of the asylum administrator. Guards at the facilities would carry blackjacks, clubs. Those who died there, and many did, often were buried in anonymous mass graves behind the asylum. Once incarcerated in this virtually medieval system, a person had few, if any, rights. This continued until two events led to an outcry for reform. The first was in 1950, undercover investigation by the California State Justice Department that exposed the terrible abuses and suffering inside Mendocino State Hospital. The second was 1962 publication of Ken Casey's novel, One Flew Over the Cuckoo's Nest, which chronicled the oppressive and dehumanizing treatment of a group of patients in an Oregon psychiatric hospital. Two pieces of legislation appear soon after. In 1963, President John F. Kennedy pushed through the Community Mental Health Act that sought to deinstitutionalize state hospitals, such as the one featured in Kinsley's book. But the most sweeping reform came about from the 1967 Lanterman-Petrus Short Act, which sought to end the inappropriate, indefinite, and involuntary commitment of persons with mental health disorders. In 1993, the California Office of Patients' Rights was created to ensure further that each person admitted to a mental health facility had access to an advocate who would, if needed, safeguard their basic rights. Now, each county is required to have at least one patient right advocate on staff. What does the patient's right advocate do? The patient's right advocate is an advisory, proponent, defender, and counselor for any patient receiving mental health treatment in the county. Patients are housed under various welfare and institution codes, known as WICs, that allow involuntary committals, beginning with WIC 5150. When a patient is deemed a danger to themselves and or to others, gravely disabled, or unable to care for themselves due to a mental health condition, they can be held involuntarily for 72 hours on a 5150. A probable cause hearing can extend that hold for 14 more days, known as a 5250, an additional 14 days, known as a 5260, and an additional 30 days that may lead to a court order for the patient to be conserved, known as a 5270. Because these holds suspend civil rights, strict guidelines must be met prior to a patient's admission to the facility. The patient's rights advocate duties include: number 1, assisting mental health staff in ensuring that such clients are informed of their rights. Number 2, performing the critical role of providing advocacy and representation for clients during the certification review hearing, which determines the legal status and the continuance of their detention on a mental health hold. 3, training and educating the staff at the mental health facility about patients' rights and advising the department on questions concerning the law and regulation surrounding holding clients. Number 4, monitoring local facilities in which county mental health clients are held. Number 5, conducting investigations to explore and resolve any issues or problems regarding a patient's rights, should any come to light involving involuntary holds and unreasonable or punitive denial of rights, such as seclusion or restraints. Number 6, monitoring present and past denial of patient rights with the help of reports issued quarterly, which the patient right advocate then forwards to the state patient's right advocate office. Technically, any person receiving or who has received mental health related treatment at any facility in the county, such as St. Joe's Hospital or the Humboldt County Correctional Facility, is a client of the PRA. But most of the PRA's clients are those admitted to Sempervirent, psychiatric health facility, or long-term care facilities. Crestwood Behavioral Health Center, each patient admitted voluntarily or involuntarily to a mental health facility should be made aware of the availability of the PRA and provided with a packet containing a brochure about the PRA's service, a release of information form, an ROI, and the PRA's contact information. The contact information is also posted in every facility with a statement of public patient rights. The Humboldt County Civil Grand Jury's investigation of the patient rights advocate. It came to the attention of the Civil Grand Jury that the county's patient right advocate was unable to perform their duties in a timely and efficient manner because they were denied critical patient information to which they had previously enjoyed access. Methodology. In preparing for this report, the Humboldt County Civil Grand Jury conducted interviews with the Humboldt County Public Guardian Office employees, conducted interviews with the Humboldt County Mental Health and Social Service employees, conducted interviews with the state level and other county patient advocates, interviewed complainants, reviewed documentation provided by interviewees, including financial accounting, researched the California guardianship and advocacy law, and gathered and collaborate statistics from other counties. Discussion. Public Guardian Office, the complaint. The Civil Grand Jury received a complaint from one of the 4 Eureka area skilled nursing facilities. The complaint stated that deputies of the Public Guardian Office were unable to participate adequately in care conferences scheduled quarterly for patients under the PGO's care. When the deputy guardian did attend the care conference, they were frequently interrupted by phone calls, which diminished the value of their participation in the conference. These conferences play an important role in treatment, providing the occasion for mental staff, omnibusmen, guardians, and sometimes the client to review the client's program, make necessary adjustments, confirm treatment goals, and even register client complaints when appropriate. Moreover, the complaint noted that the guardians were having trouble performing basic services for their clients, such as shopping for clothes or acquiring a cell phone, in a timely fashion. Frequently, the task of securing such day-to-day items was falling to the staff of the facility or care home in question, and in some cases to no one at all. Chronic understaffing in the Public Guardian Office undermines its ability to address the interests of residents in such facilities. In addition to the increased attention of the deputy public guardians, the complaint seeks a closer collaboration between the staff of skilled nursing facilities and the Public Guardian Office. After undertaking a series of interviews and visiting facilities holding clients of the Public Guardian Office, the Civil Grand Jury determined that the performances of the Humboldt County Public Guardian Office was severely impacted by excessive caseloads. Several individuals who expressed dissatisfaction with the PGO's overall service to clients in the SNFs generally agreed that the guardians were hindered in fulfilling their obligations because of their excessive caseload, which are reportedly in excess of 90 clients each. See Figure 1 below. This number is beyond the 70 or so cases that workers identified as a manageable caseload and far beyond the 30 to 40 client workload that is considered ideal. To guardians often scrambling to locate their most at-risk clients, the relatively secure SNF residents are deemed a lesser priority because they are safely housed and fed and often have a source of income in trust. Several factors contributed to this state of affairs. First, Humboldt County has an inordinate amount of persons who are being served by the Public Guardian Office. The county's per capita population of conserved patients is far in excess of other California counties. Second, requests to the DHHS and to mental health, to which the PGO answers, for funding to be allocated for a new deputy public guardian position have gone unheeded for years. Third, one of the 3 deputy public guardians have taken an extended medical leave, and that staff's member entire caseload was simply shifted to the remaining 2 deputies, the assistant PG and the lead PG. The standard of care for many of the PGO's clients has clearly suffered with the resulting increase in caseload. Growing caseloads, shrinking workforce. Humboldt County Mental Health proposed budget for this fiscal year is $46.6 million, just over $28 million of which represents salary and benefits. Yet, despite the unusually high demand in Humboldt County and the desperate need for well-staffed, highly efficient public guardian office, mental health administrators have not advocated that this office become a program, even as mental health maintains separate budgets for the program, like Healthy Mothers, Substance Abuse Disorder, and HUMWorks. This last with a budget of just $20,000. The PGO is expected to serve its nearly 490 clients, an extraordinarily high number compared to other counties, without its own budget and without sufficient autonomy. As a result, the PGO must compete with other offices for a slice of the general fund. This has led to problems. Documents provided to the Civil Grand Jury show that the number of clients under the care of Humboldt County Public Guardian Office has increased steadily for several years, and that this trend only seems destined to continue. Currently, 4 workers serve around 700 clients of various types and needs. Of these, some 200 or so are clients for whom the office handles just one aspect of their lives, the financial part, such as Social Security or disability checks. That leaves approximately 500 clients who require a staggering range of services and needs, from intervention in serious drug abuse to management of financial affairs to onerous tasks such as locating personal papers in a packet mobile home to the mundane such as getting the client new pajamas. The unique challenges faced by Humboldt County Public Guardian are immediately apparent when its workload per case worker is compared to those of other counties. Humboldt's average number of clients per guardian or caseworker exceeds not only that of counties of similar population, but far outstrips peer counties such as Mendocino, Shasta, and Yolo, but also that of counties that are many times its size, as is shown in a graph here. These numbers are startling. Humboldt County's inordinately large population of conserved clients is a deeply concerning statistical anomaly that makes present questions about the administration's oversight of and responsiveness to the PGO even more urgent. Humboldt County's total conserved is half of the total conserved in San Mateo County, which has a population 5 times greater than that of Humboldt. The latter's average caseload is about 1/3 greater than what a guardian of San Mateo serves. The total population of either Santa Barbara or Solano counties is 3 times that of Humboldt, yet their guardians are responsible for roughly half the number of cases of a Humboldt County guardian, and their total number of clients is specifically lower than that of Humboldt. Moreover, the number of conserved per capita in Humboldt County is far higher than any of the counties listed above in the chart. Humboldt has 363 conserved persons for every 100,000 residents. Del Norte, whose total population is just under 2/3 of Humboldt's, has 84 conserved patients for every 100,000 residents. There is even reason to believe that these disparities in total clients and clients per guardian between Humboldt and other counties will continue to grow, particularly because of the inevitable care which will be required for the aging boomer generation. Early data suggests that Humboldt County is beginning to see the effects of the present global COVID-19 pandemic on the public guardian's workload, as the middle and the lower classes begin to feel the economic impact of job losses, business closures, shrinking earnings, and the number of those requiring help from the PGO will naturally rise. Moreover, the $54 billion state-level budget deficit expected as a result of COVID-19 has forced California to consider deep cuts to the state's funding of health and education. This will almost certainly impact the counties financially. While the total number of clients served by the PGO has climbed steadily over the years, its excessive average caseloads reached stratospheric levels of one of only 3 deputy public guardians began an extended medical leave of absence in late 2018. That continued to this day. Although many institutions commonly deal with such absences of key staff members by hiring a temporary or contract worker to assume part or all of the absent employee's workload, the terms of the present Memorandum of Understanding between Humboldt and the American Federation of State, County, and Municipal Employees forbid the hiring of a substitute appointment for an employee who is on leave with pay. Nevertheless, the PGO attempted at some point to hire additional temporary staff from its own small budget in order to alleviate heavy burdens on each deputy public guardian. Such funding would come from the PGO's Representative Payee program, which generates about $15,000 to $16,000 per month in revenue by collecting a monthly fee from probate clients who are drawing Social Security in exchange for the management and distribution of those payments. While the PGO made some efforts in the past 6 months to hire temporary staff, it is unclear how successful they were. The immediate result of this sudden loss of deputy meant that existing staff of the PGO was forced to distribute that absent deputy's caseload of 87 clients among the remaining public guardians and among the administrative staff indefinitely. The average number of clients per guardian thus increased from 70 to 110 overnight, at least a 64% increase above the average guardian's caseload in other California counties. Mental health response. The national solutions to such high caseloads in the PGO would be the creation of a new position to handle the client overload and filling the existing deputy position that presently sits vacant. Every year, the financial sector of DHHS Employee Services solicits the directors of the departments and offices within DHHS to make official requests for those specific needs for the following budget year. The burden of requesting approval to hire in one of the DHH various departments apparently rests chiefly on supervisors, who must argue for a specific need and explain the consequences of failing to address it. In each of the last 2 years, the PGO officially requested that funding by allocate to create an additional position for a new deputy. While the current preliminary approval of funding to hire a new deputy is a welcome development, the Civil Grand Jury was troubled by DHHS' seemingly delayed response to the increasing challenges faced by the PGO. Documents indicate that a new deputy position in the PGO has not yet been approved in the last 20 years. The difficulty of securing funding for a new position is surely affected by the structure of the DHHS funding. Because the PGO receives very little external funding, its cost must be covered by the county's general fund, which supplies very little of mental health's considerable budget. Yet it is still unclear why DHHS and mental health were so slow to respond to the increasingly dire situation of the PGO's staffing. When seeking some explanation for this failure to hire a new deputy, the Civil Grand Jury was told that there was no obstacle to hiring additional deputies, and that the problem may have been one of communication between supervisors. The Civil Grand Jury was troubled by the response that such requests for hiring were, quote, the responsibility of the supervisor, and that, quote, sometimes supervisors do not ask loud enough, unquote. While DHHS' current plan to hire a new deputy is a reason for optimism, it is worth underscoring just how much longer it will be before the public guardian receives any relief. DHHS has merely earmarked the funding to its current budget, which still awaits approval by the Board of Supervisors. If approved, Employee Services only begins the hiring process starting July 1st. After the necessary soliciting of applicants, screening of candidates, and completion of paperwork and required training, many months will have passed before the newly hired deputy can even begin to relieve the enormous workload that has accrued over several years. Moreover, following the hiring process, it takes at least a year of training before a new guardian can work on their own. If even the citizens of this county needed excellence in governance, it is in the administration of this most crucial of public services, the Public Guardian Office. Public rights advocates the complaint. Like the Public Guardian, the Office of the Patient's Rights Advocate is also overseen by the Department of Mental Health. Evidence gathered by the Civil Grand Jury suggests that the efficient working of this office would also negatively affect by the department's practices. The primary issue concerned the department's interpretation and implementation of its policies, practices of privacy and patient confidentiality. Specifically, the Health Insurance Portability and Accountability Act of 1996, HIPAA. Humboldt County's Department of Mental Health understandably privileges the privacy of its clients and observes federal law governing such protections. The Civil Grand Jury found that while the legal basis of mental health policy is sound, its interpretation and implementation adversely affects the PRA's mission and patients in mental health facilities. The following practices would benefit from consideration. The redaction of the patient information from the daily census and periodic reports on the denial of rights orders, both of which are supplied to the PRA, and the PRA's exclusion from meetings where sensitive information must be discussed. While confidentiality policies may be guided by law, they also make the PRA's important work much harder and, worse, may prevent the PRA from meeting state-mandated obligations to advocate for clients, report significant statistical data, and monitor county facilities. In the event of a client lawsuit, current practices might even be construed as obstruction, and for this reason alone should be carefully reconsidered. The Civil Grand Jury was interested in learning the justification for this new interpretation of patient confidentiality, and more importantly, whether mental health specific practices for the preservation of patient confidentiality potentially hindered and even prevented the PRA from effectively doing their job. The redacted census. Mental health did not always implement its confidentiality policy as it does currently. Before October 2019, the ward clerk at Semper Virens routinely faxed to the county PRA and to other staff members a daily census listing the name, date of birth, case number, date of admission, legal status, financial status, and type of hold for which each patient currently housed in the facility. While the kind of data included in the census may vary from county to county, the census is a common tool for helping a PRA learn of new admissions, easily locate patients within a facility, and keep track of their legal status. In October 2019, Mental Health Administration decided the census would be redacted to exclude the name, birth date, and case number of all patients for whom the PRA did not have an existing signed release of personal information, or ROI. The explanation given for this sudden change in practice was that such patient data, even the disclosure of the name of the patient at the facility, constituted a violation of confidentiality according to WIC 5541. which requires a client's authorization before a PRA can access confidential records or information. WIC 55325.1 and the patient's Bill of Rights state, respectively, that all persons with mental illness have a right to privacy and the right to be treated confidentially, with access to their records limited to those involved in their case or designated by that patient. In addition to parts of the census, the list of clients being held under LPS holds was also withheld from the PRA by mental health administrators. The civil grand jury heard from multiple sources that the new practices was, in effect, a hindrance to the performance of the PRA's advocacy duties. Information that was previously accessible to the PRA now required additional time-consuming work in a job that already requires rigorous adherence to procedure for its various duties and mandated deadlines. A PRA services as advocate during a patient's hearing regarding the legality, status, necessity of mental health holds. To file the necessary paperwork, the PRA must access a patient's file. The previously unredacted census allowed the PRA to complete the paperwork and prep for the impending hearing from the PRA's office. The implementation of the new policy introduced a new, even Byzantine level of bureaucratic process. The advocate must now first visit each facility and, moving from room to room, determine whether clients have been admitted who may need their services, and second, engage clients in the middle of an often involuntary and even traumatic mental health hold to persuade them to make the rational, calm decision to sign the ROI. If the PRA successfully secures the release, the advocate must then enlist the help of the facility's ward clerk, who enters the information in the system. Only after the clerk enters the ROI into the county computer system can the PRA access the patient's records and return to their office to complete the necessary paperwork. Processing the ROI usually takes 24 hours. Moreover, the added cost of the daily clerical work to redact from the census information about the patients who lack an ROI is unjustified. This onerous process becomes potentially problematic when it occurs around the lead up to the semi-weekly hearings. Legal proceedings that determine the status and possible extension of a hold for a patient in the facility. A hearing must take place within 3 days of admission. If there is any delay in acquiring an ROI from a patient, the PRA could be forced to make repeated trips to the facility on the same day, to the facility for an ROI, back to the office to complete the paperwork, and then back to the facility for a hearing. The patient needs a prepared advocate as they enter a hearing to face recommendations by professionals and officials well versed in the process and procedures of holds. When gauging the added cost of the redacted census in the PRA's time and energy, one must remember that one single PRA services all mental health clients in the entirety of Humboldt County. Clients are found not only at Sempervirens and Crestwood, but technically at any facility where patients receive care, including but not exclusive to St. Joseph's Hospital, Humboldt County Correctional Facility, and various homeless shelters. Moreover, the PRA is responsible for Humboldt patients who are held in facilities outside the county. The advocate's job is further complicated because clients are people who complex family lives and health histories can be exacerbated by any number of contingencies. The nature of mental health emergencies sometimes preclude the possibility of acquiring a single ROI. Distressed individuals may lack the wherewithal or ability to understand their rights or file a complaint. Psychosis, mania, heavy medication, or other such mental or physical debilitating can prevent patients from willingly releasing their information to the PRA in a timely fashion. Moreover, some patients will have a weaker grasp of their rights and what constitutes a violation of them. At worst, such reduced access could complicate the PRA's legal duty to act as an advocate for patients or residents who are unable to register a complaint because of their mental or physical condition, as mentioned in Title IX CCR 862.2. Mental health administration should be facilitating the PRA's workload. Instead, they are forcing the PRA to work blindly, as one source described the change in practice represented by the redacted census. Denial of rights statistics. The implementation of the confidentiality policy also potentially impedes the PRA's mandated obligation to report to the state the accurate and statistics of denial of right orders in county facilities. A denial of right order is an official process whereby a civil right is removed from a patient for a, quote, good cause by the person in charge of the facility, noted in WIC 5326. Every denial of right or rights must be recorded by the facility, Title IX, CCR 865.3. And these statistics are forwarded quarterly to the state's Office of Patients' Rights, the state legislature, and the county's Board of Supervisors. Information reported includes the number of persons whose rights were denied and a description of the right or rights. WIC 5326.1. According to Humboldt County's job description, 2017, of the PRA, the advocate must collect, compile, and submit this report. However, the monthly and quarterly reports detailing the use of seclusion and restraints currently provided to the PRA are redacted of any identifying patient information, apparently even if identifying information about patients who have signed on RO. The absence of such information potentially reduces the accuracy of statistical data about the county's denial of rights and hampers any effort to determine what percentage of right denials involve specific individuals, the extent to which such denials were supported by good cause, and any unusual or problematic patterns in facilities regarding denial of rights. This is especially true of incidences involving patients who are no longer at the facility, so they can no longer be questioned directly. Only mental health officials, nurses, physicians, and administrators have access to the complete records, and they alone reserve the responsibility to identify and report any potential significant denial of rights connected to specific clients. In other words, mental health reserves for itself sole responsibility for adjudicating statistics about patients who are denied rights in the care of the mental health department. The primary check on the incident of seclusion and restraint on mental health patients in Humboldt County is mental health itself. This policy has led to the PRA currently not investigating any denial of rights, although such investigations are mandated by WIC 5270. Continuous quality improvement meetings. The Civil Grand Jury identified continuous quality improvement meetings, or CQIs, as another area of concern. The mental health administrator is required to conduct meetings at least 10 times annually to review and analyze the department's programs for possible improvement. These meetings cover a great deal of information and data regarding the effectiveness of in- and outpatient care and are attended by the department's leadership and certain community stakeholders. Together, they evaluate the extent to which their department is implementing the best practices and highest level of professionalism and efficiency in its policies, regulations, and procedures. The confidential nature of the information reviewed and discussed at these CQIs meetings requires that patient confidentiality be protected. Ostensibly, in order to protect such confidential information, the Mental Health Administration excludes the PRA from any part of the CQI meeting in which any personal information about patients who have not signed an ROI is discussed. While it may align with the laws protecting confidentiality, such practices is nevertheless one interpretation of the law and may conflict with the PRA's duty to interpret and report statistics of the denial of rights and investigate and resolve complaints regarding violations or abuses of rights. In the event of a suspected violation, the PRA is required to launch an investigation to ascertain the cause of denial of rights and bring this to the attention of the department administrators. Thus, the PRA's multifaceted job requires them to act as a consultant, a representative, a trainer, an investigator, and a liaison between the county and the state. The PRA's performance of this critical role is dependent on access to all pertinent information, not just which denial of rights occur and how often, but also who was denied rights, for what reason the actions were taken, and how often this occurs. Given the PRA's obligation to produce a fully informed report to the state, it is fair to ask whether the county's interpretation of patient confidentiality, insofar as it places limits on the information available to the PRA, is reasonable. Another result of these restrictions placed on patient information has been the PRA's present suspension of two of the job's central tasks: to monitor facilities continually and to train staff for compliance with patients' rights, laws, regulations, and policies. Out of fear for going astray of the administrator's strict enforcement of confidentiality, the PRA has been reluctant to perform these duties. Implementing patient confidentiality. The PRA asked mental health for an explanation of this new policy restricting access to patient information. Formal and informal responses by the DHHS and Mental Health Administration have defended the practices as an effort to err on the side of confidentiality, quote unquote, and argue that such patient information is mostly irrelevant to the PRA's basic duties. Moreover, it maintains that the PRA's reasoning for requesting a faxed, unredacted census to avoid unnecessary travel to supervirans is moot because the county's description of the position requires the PRA to visit facilities daily. According to the Department of Mental Health, there are but 3 occasions when the PRA is permitted to access to these records: when responding to a complaint from a patient who has provided authorization through an ROI, when conducting monitoring activities according to the WIC 5520 to 5522, but only with records that have been de-identified, not protected health information or any names, and when rights are denied and patients are reported under the 5326.1, and with all identifying information redacted. A review of all statements and documents concerning mental health policy of patient confidentiality confirms that it is informed by current law. In implementing this policy, however, mental health interprets such laws as strictly and narrowly as possible. When it comes to the duties of the PRA, for example, which WIC 5325.1 and the Patient's Bill of Rights restrict access to patient records, it does not explicitly forbid nor allow disclosure of the patient's names nor location on the census or the list of LPS patients requested by the PRA. Since the statutory language is broad, it is up to the medical providers, patient, and advocate to interpret whether a specific situation would be covered by WIC 5325.1 and whether the disclosure would be in compliance with HIPAA. The privacy law rule explicitly permits certain incidental disclosures to the extent that the entity, in this case DHHS, has applied reasonable and appropriate safeguards and implemented the minimum necessary standards where appropriate, e.i. continuous HIPAA training and signed confidential agreements. Furthermore, mental health does not adhere to such strict enforcement of confidentiality across the board. One example is the nurses' station's whiteboard. The PRA receives a paper census without the patient's names and location in sempervirent. Yet information about patients currently being held in the facility, specifically the first name and location of each patient on hold, is in fact featured on a whiteboard posted in the nurse's station. While patient confidentiality is defined as strictly as possible in mental health documentation, where it justifies restricting the PRA's access to client information, it is defined much more broadly in practice at each particular facility. Moreover, it is unclear whether disclosure of this specific basic information in a census truly constitutes a violation of patient confidentiality when other counties in the state can and do routinely furnish such data to their PRAs without the condition of patient release. While Mendocino and Shasta counties redact the census, the Butte County PRA receives complete nightly updates via email. PRAs from larger counties such as San Francisco and Monterey receive complete census forms. It is difficult to believe that a county like San Francisco, which faces a large and acute public mental health problem, is breaking the law on a much larger scale by affording its PRAs a full census. Moreover, when the Humboldt County PRA needs to check on clients housed in Shasta County, that county furnishes a complete census to them. The above examples make clear that there is a certain amount of flexibility in the interpretation of patient confidentiality in counties throughout the state. While codes like WIC 5541 and the Patient's Bill of Rights surely afford Humboldt County's Department of Mental Health sufficient legal basis for limiting access to a patient's records, it is difficult to see how this applies to the Humboldt County PRA when they are a staff member of a HIPAA entity and have thus signed the confidentiality agreement required of all DHHS employees. As an organization covered by HIPAA, DHHS ensures compliance with HIPAA's protections of the privacy and security of health information by requiring annual training for all employees, including the PRA. The DHHS Manual on Privacy and Security Training states explicitly that employees who complete the training can look at and use a person's confidential information if they need it to do their job. Mental health is not legally bound to restrict the PRA's access, especially when it comes to investigating denial of rights. The PRA can be given access to client information and records if the mental health director chooses to delegate responsibility for such an investigation. WIC 5326.1 and WIC 5326.9. Both Monterey and San Francisco counties outline processes by which a county mental health director can designate responsibility to investigate denial of rights to a PRA who is granted access to full client information. Moreover, a recent report prepared by the California Office of Patient Rights conclude that such a decision by Humboldt County to include in its policies similar delegation procedures for denial of rights would be supported by the law and best practices for a PRA program. Findings. Finding number 1. The Public Guardian Office is understaffed. R1, R2, and R3. Finding number 2. Mental health, which administrates the Public Guardian Office, did not take sufficient proactive measures to help the Public Guardian Office manage the increased caseload when a key staff member took extended leave. Recommendation 1, 2, and 3. Finding 3. The present public guardians are unable to meet their obligations to clients adequately because they are burdened with inordinary high caseloads. Recommendation 1 through 3. Finding 4. The Humboldt County Memorandum of Understanding with employees has language that restricts the replacement of employees when a full-time employee is out on a prolonged medical leave. Recommendation 3. Finding 5. The mental health administrator's interpretation of confidentiality creates obstacles that prevent the patient right advocate from serving clients' needs, despite the advocates having a signed confidentiality agreement and having undergone the county's annual HIPAA training. Recommendation 4, 5, 6, and 7. Recommendations. Recommendation 1. The Humboldt County Civil Grand Jury recommends that the Board of Supervisors ensure that adequate funding is budgeted for the hiring of an additional deputy public guardian. Finding 1 through 3. Recommendation 2. The Humboldt County Civil Grand Jury recommends that the Department of Health and Human Services hires an additional, a 4th, deputy public guardian in order to ensure the office can manage its caseload. Finding 1, 2, and 3. Recommendation 3. The Humboldt County Civil Grand Jury recommends that the Department of Health and Human Services develop and implement a process to mitigate the effects of the increased workload on remaining staff when a staff member takes an extended leave. Findings 1, 2, 3, and 4. Recommendation 4. Humboldt County Civil Grand Jury recommends that mental health ensure that the patient right advocate have full access to patient information relative to their duties. Finding 5. Recommendation 5. The Humboldt County Civil Grand Jury recommends that mental health ensure that the patient's rights advocate be provided with an unredacted census on a daily basis. Finding 5. Recommendation 6. The Humboldt County Civil Grand Jury recommends that mental health ensure that the patient's rights advocate be provided unredacted denial of rights reports with patient's information. Finding 5. Recommendation 7. The Humboldt County Civil Grand Jury recommends that the mental health welcome the patient right advocate to the entirety of the continuous quality improvement meetings without restriction. Finding 5. Request for responses. Pursuant to Penal Code Section 933.05, the Humboldt County Civil Grand Jury requests responses as follows. From the following individuals within 60 days, they request Humboldt County Department of Health and Human Service Director Connie Beck respond to finding 1 through 5 and recommendation 1 through 7. From the following government bodies within 90 days, they request that the Humboldt County Board of Supervisors respond to finding 1 through 4 and recommendation 1 through 3. Reports issued by the grand jury do not identify individuals interviewed. Penal Code Section 929 requires that reports of the grand jury not contain the name of any person or fact leading to the identity of any person who provides information to the grand jury. This concludes the reading of the Civil Grand Jury's report. Thank you.